Before we begin, a quick and important disclaimer. The following content is provided for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. The history of family law and divorce in the United States is complex and varies significantly by jurisdiction and time period. While we explore historical trends and case studies, this information should not be used as a substitute for the counsel of a licensed attorney or a qualified professional in your specific state. We strongly encourage all viewers to conduct their own due diligence and seek professional guidance regarding their individual circumstances. For the vast majority of the 20th century, if you were a father in the United States and your marriage came to an end, you were effectively a ghost in your own home. In 1920, a father facing divorce was essentially staring down a legal system that viewed him as little more than a walking paycheck, while society viewed him as a moral failure. There was no such thing as 50-50 custody. There was no co-parenting plan. There was only the tender years doctrine, a legal presumption that suggested mothers were uniquely and exclusively qualified to care for children, leaving fathers to watch their families disappear behind a curtain of court orders and social stigma. We often think of the fatherless home as a modern phenomenon, but the seeds of the modern custody battle were planted over 100 years ago, in an era of rigid gender roles and draconian divorce laws. Today, we are peeling back the layers of a century-long transformation. We are looking at why, for decades, the American legal system intentionally pushed fathers to the periphery, and how those historical trends created the complex, often frustrating landscape that divorced dads navigate today. This is not just a history lesson. It is a deep-dive masterclass into the evolution of the American family. By understanding where we came from the Victorian era's property-based custody to the guilt-based divorces of the 1950s, you will gain a profound understanding of why the system operates the way it does today, and how the definition of fatherhood has been radically redefined through the lens of the law. To understand the plight of the divorced father in the 20th century, we have to look at the massive tectonic shift that occurred just as the 1800s ended. For centuries under English common law, which the U.S. inherited, children were technically considered the property of the father. If a marriage ended, the father kept the children because he was the one with the economic means to support them. However, as the United States moved into the Industrial Revolution, everything changed. Men were pulled out of the home and the family farm and into factories and offices. This physical separation created a new social narrative, the cult of domesticity. Suddenly, the home was the woman's sphere, and the world of work was the man's sphere. Judges began to rule that because fathers were no longer present in the home during the day, they were inherently less capable of nurturing children. This led to the rise of the tender years doctrine. This legal principle suggested that during a child's tender years, generally regarded as under the age of 7, the mother's influence was paramount. In practice, however, this doctrine often extended until the child reached the age of majority. Historical trends show that by the 1920s, the presumption had flipped entirely from the father to the mother. If you were a father in 1925 seeking custody, the burden of proof was not just high, it was nearly impossible. You had to prove that the mother was unfit, a legal standard that usually required proving she was a chronic alcoholic, physically abusive, or flagrantly immoral by the standards of the day. Without such extreme evidence, the father was granted visitation, which in the early 20th century often meant a few hours every other Sunday, usually supervised or limited to public spaces. The economic reality of the 1930s added another layer of complexity to this historical evolution. During the Great Depression, the role of the divorced father became even more precarious. Case studies from this era reveal a legal system that was obsessed with the breadwinner model. If a father lost his job, as millions did, he didn't just lose his income. He often lost his legal standing to see his children. Courts of the time frequently tied visitation rights directly to the consistent payment of alimony and child support. If the provider could not provide, the system saw little reason for him to remain in the family circle. This period solidified the deadbeat dad archetype in the American psyche, even when the absenteeism was a direct result of economic collapse rather than personal choice. Furthermore, we must examine the fault-based divorce system that dominated the first half of the century. Before the 1970s, you couldn't just get a divorce because you were unhappy. You had to prove grounds. This meant someone had to be the villain. Whether it was adultery, extreme cruelty, or abandonment, the legal process was designed to be adversarial. For a father, being the defendant in a fault-based divorce often meant being branded as the person who destroyed the family. This moral branding had long-lasting consequences in custody hearings. If a judge found a father at fault for the breakdown of the marriage, that moral failing was frequently used as a justification to limit his access to his children, regardless of his actual parenting ability. Let's look at a hypothetical but representative case study from 1945. A soldier returns from World War II to find his marriage has crumbled under the strain of the war years. In the 1940s, the best interests of the child was a term that existed in theory, but in practice it was interpreted through a lens of extreme gender bias. The father, despite having served his country and being a dedicated parent prior to the war, would likely be told by a judge that the child needed stability, which was coded language for the mother's home. The father was expected to return to the workforce, pay a significant portion of his earnings to a household he was no longer allowed to live in, and accept a role as a peripheral figure in his children's lives. This created a generation of shadow fathers, men who were legally and socially relegated to the role of the fun uncle on weekends, while carrying the full financial weight of a traditional household. The psychological toll of this era cannot be overstated. Historical data from mid-century sociological studies indicates that divorced fathers during this period often suffered from a loss of identity that was rarely discussed in public. Because a man's value was so intrinsically tied to his role as the head of a household, losing that role meant losing his place in the social hierarchy. There were no support groups for divorced dads in 1950. There were no books on how to be a successful long-distance father. You were simply expected to pay your dues and fade into the background. As we move deeper into this series, we will see how the 1960s and 70s began to crack this foundation. But to understand the modern struggle, you have to realize that the system wasn't broken by accident. It was built this way on purpose. It was built on the assumption that men were providers and women were nurturers, and that those two roles were mutually exclusive. The century of fatherhood is the story of men fighting to prove that they could be both. We are going to explore the legal battles of the 1970s where fathers began to challenge the tender years doctrine on constitutional grounds, and how the rise of no-fault divorce changed the game forever, for better and for worse. This first part of our deep dive sets the stage for a revolution that is still happening in family courts across America today. We are moving from an era where the father was a property owner, to an era where he was a paycheck, and eventually to the modern era where he is fighting to be an equal partner in the lives of his children. Stick with us because the shift from the silent generation dad to the modern girl dad, or co-parenting pro, is a journey through law, economics, and a radical shift in the American heart. To grasp the true magnitude of the transformation that took place as we entered the middle of the 20th century, we have to look at the massive cultural and legal explosion of the late 1960s and early 1970s. Imagine if you are a father named David in 1969. David lives in a quiet suburb of Indianapolis. He works 45 hours a week at an insurance firm, he mows his lawn every Saturday, and he is deeply involved in his son's Little League team. But David's marriage is ending. In 1969, David is living in the final moments of a legal era that essentially viewed him as an optional participant in his child's daily life. At this point in historical trends, the legal system was still operating under a guilt-based framework. If David wanted a divorce or if his wife wanted one, they had to engage in a public, often brutal display of finger-pointing. They had to prove a fault like adultery, extreme mental cruelty, or desertion. This was the era of the private investigator, the staged photographs of infidelity, and the high-stakes courtroom drama where a father's character was shredded to justify the dissolution of the household. But then the ground shifted. In 1969, California Governor Ronald Reagan signed the Family Law Act, which created the first no-fault divorce system in the United States. This was a seismic shift that would eventually ripple across every state. The potential outcomes of this legislation were complex. On one hand, it allowed people to leave unhappy or abusive marriages without the need for public shaming or fabricated evidence. On the other hand, it completely removed the traditional leverage fathers had held. Under the old system, if a father was not at fault, he could sometimes negotiate for more time or a better settlement because his consent was required to finalize the split. With the advent of no-fault divorce, the barrier to exit dropped, and the sheer volume of divorce cases began to skyrocket. Historical trends show that between 1960 and 1980, the divorce rate in the United States more than doubled. This created a massive sudden population of divorced fathers who were navigating a system that was still fundamentally built on the 1920s tender years doctrine. While the grounds for divorce were modernizing, the standards for custody were stuck in a time loop. the courts moved from the tender years doctrine to what we now call the best interests of the child standard. On the surface, this sounds like a progressive, child-centered approach. However, in the early 1970s, the best interests of the child was often interpreted through a lens of extreme traditionalism. Case studies from this period reveal that judges almost always determined that a child's best interest was to stay with the mother, while the father was relegated to being a visitor. Let's look at a step-by-step breakdown of how a custody hearing for our hypothetical father, David, would have played out in 1972. First, David would have to request visitation rights, which were not guaranteed. The judge would look at David's work schedule. Because David worked a standard 9 to 5, the court would argue that he was unavailable to provide the daily nurturing a child required. Second, the court would examine the physical home. If David had moved into a small apartment after the separation, the court would often rule that the environment was unsuitable for children, further limiting his time. Third, and perhaps most crucially, the court would rely on the testimony of social workers who were often trained in the psychological theories of the 1950s, which emphasized the primary bond between mother and infant above all else. This psychological backdrop is essential to understanding the deep-dive history of this era. During this time, theories like John Bowlby's attachment theory were frequently used in family courts. While Bowlby's work was groundbreaking in understanding human development, it was often simplified by the legal system to imply that a child could only have one primary attachment figure, and that figure was, by default, the mother. Fathers were seen as secondary figures who provided play and discipline, but were not essential for emotional security. This created a legal environment where a father who wanted 50-50 custody was seen as not only unusual, but potentially harmful to the child's psychological stability. The potential outcomes for fathers who fought these presumptions were often demoralizing. They were frequently told by their own attorneys to stay quiet and accept every other weekend visitation because asking for more might make them look aggressive or unstable in the eyes of the judge. However, as we move into the mid-1970s, something began to change in the American consciousness. This was the era of the second-wave feminist movement, which argued for women's rights to enter the workforce and achieve equality in the public sphere. Ironically, this movement also began to open the door for fathers in the private sphere. If women were to be equal participants in the economy, it stood to reason that men should be equal participants in the home. Case studies from the mid-70s show the very first inklings of the fathers' rights movement. These were groups of men who began to organize and protest, pointing out the inherent hypocrisy of a system that demanded they pay 100% of their financial obligations while granting them access to their children for only 15% of the time. Imagine if you were part of one of these early advocacy groups in 1976. You would be meeting in basements and community centers, sharing stories of how the legal system had effectively erased your presence from your children's lives. You would be looking at statistics that showed how children of divorce were struggling, and you would be arguing that the solution wasn't just more money from the father but more time with the father. This was the beginning of the shift toward the concept of joint custody, but the road was incredibly steep. In 1975, joint custody was practically unheard of in most U.S. jurisdictions. It was viewed as a radical, experimental arrangement that would cause nothing but confusion for the child. The legal battles of this time were often centered around the primary caregiver standard. This was a new way for the courts to maintain the status quo without explicitly mentioning gender. The court would ask, who has been the primary caregiver for the majority of the child's life? Because of the economic structures of the time, where fathers were overwhelmingly the primary earners, the answer was almost always the mother. This created a catch-22 for fathers. By working hard to provide for their families and fulfill their role as the provider, they were effectively disqualifying themselves from being viewed as a primary parent in the eyes of the law. This paradox is one of the most painful chapters in the history of American fatherhood, as it penalized men for succeeding in the very role society had demanded they play. By 1979, the tension between the old world of the tender years doctrine and the new world of gender equality was reaching a breaking point. This tension was captured perfectly in the 1979 film Kramer vs. Kramer, which shocked the American public by showing a father who was not only capable of caring for his son, but was arguably the more stable parent. This cultural moment signaled a massive shift. People began to ask, if a father can learn to cook, to soothe a crying child, and to manage a household, why does the law still treat him like a guest? As the decade came to a close, the stage was set for a massive legal revolution in the 1980s, the decade where joint custody would go from a radical experiment to a legal reality. But as we will see in the next part, This victory for fathers came with a whole new set of challenges, including the rise of the child support enforcement system and the complex new world of co-parenting. We have to ask ourselves, was the legal system ready for fathers who actually wanted to be parents, or was it just finding new ways to keep them in a box? The 1980s would bring the answer, and it wasn't what anyone expected. How did the introduction of computerized child support tracking in the 1980s fundamentally change the way the state viewed the relationship between a father and his child? We are about to dive into the era of the child support revolution and the birth of the modern custodial battle. The 1980s arrived with a sharp clinical edge that fundamentally reshaped the American father's relationship with the state. While the 1970s were characterized by cultural shifts and the first cracks in the tender years doctrine, the 1980s were about codification, calculation, and the federalization of the family. To understand how we arrived at the current landscape in 2026, we must examine the moment when the father's role was distilled into a series of mathematical equations and federal mandates. This was the era of the child support revolution, a period that transformed the biological father into a legal entity known as the obligor. The catalyst for this shift was not necessarily a desire for family equity, but rather a mounting fiscal crisis. By 1980, the United States was seeing a massive increase in the number of single-mother households relying on the Aid to Families with Dependent Children or AFDC program. The federal government, under the Reagan administration, began to view unpaid child support not just as a private family matter, but as a direct drain on the public treasury. Historical trends during this decade show a pivot where the state stepped in to act as the ultimate debt collector. The Child Support Enforcement Amendments of 1984 were a watershed moment. For the first time, states were required to implement aggressive collection techniques, including wage withholding and the interception of federal tax refunds. Imagine if you were a father named Mark in 1985, living in a mid-sized city like Columbus, Ohio. Under the new 1984 amendments, Mark wouldn't just be expected to write a check every month. The state had the power to reach directly into his paycheck before he even saw it. This was a radical departure from the 1950s and 60s, where child support was often treated as a secondary priority by local courts. For Mark, this meant that his identity as a father was now inextricably linked to his status as a taxpayer and a debtor. If Mark fell behind, the potential outcomes were no longer just a stern lecture from a judge. He faced the very real possibility of losing his professional licenses, his driver's license, and eventually, his freedom through civil contempt charges. This era solidified the pay-to-play dynamic that has haunted family law for 40 years. However, the most significant shift came with the Family Support Act of 1988. This legislation took the localized, often arbitrary decisions of individual judges and replaced them with mandatory statewide guidelines. Before 1988, a judge might look at a father's situation and decide on a support amount based on a gut feeling or a quick look at his lifestyle. After 1988, every state was required to establish a formula based on income. Case studies from this period highlight the income shares model and the percentage of income model. In the income shares model, the court would estimate the total amount of money parents would spend on a child if they were still living together, and then divide that amount between the parents based on their respective incomes. On paper, this was an attempt at fairness. In practice, it often failed to account for the actual costs of maintaining two separate households. As these financial structures were being built, the legal battle for time was also intensifying. The 1980s saw the first widespread adoption of joint custody laws. California had led the way in 1980 by making joint custody a preferred option, and many other states followed suit. But there was a massive disconnect between the label of joint custody and the reality of the schedule. This is where we see the birth of the standard possession order. For millions of American fathers, joint custody in the 1980s and 90s didn't mean 50-50th time. It meant the first, third, and fifth weekends of every month. This rigid template became the default setting for the American judiciary. Step by step, the system created a visitor class of fathers. First, the 1988 Act ensured the money was tracked and collected with bureaucratic precision. Second, the best interests of the child standard, while moving away from gendered language, still heavily favored the primary caregiver, which, as we discussed in the previous part, almost always favored the mother due to existing economic structures. Third, the standard possession order provided a path of least resistance for overworked judges and attorneys. It was easier to apply a template than to craft a bespoke parenting plan. For a father like Mark in 1988, he might have joint legal custody, which gave him a say in major medical or educational decisions, but he still only had 4 or 5 days a month of actual physical custody. This disconnect created a toxic environment that still impacts families in 2026. Because child support formulas were often tied to the number of nights a child spent with each parent, time literally became money. If a father asked for more time, the mother might see it as an attempt to lower his child support obligation. If a mother refused more time, the father might see it as a way to maximize her monthly payment. The legal system had inadvertently turned the parent-child relationship into a high-stakes financial negotiation. Historical trends indicate that this period saw a massive spike in litigation, as parents fought over overnights, with the same intensity that corporations fought over quarterly earnings. Furthermore, we must look at the psychological impact of the obligor status. When the state's primary interaction with a father is through an enforcement agency, it changes how that father views himself. Case studies of fathers in the late 80s and early 90s show a rising sense of paternal disposability. These men felt that their only value to the system was their utility as a source of revenue. This led to the disappearing dad syndrome, not because these men didn't care, but because the emotional pain of being a visitor and a debtor was too much to bear. When you are told by the law that your presence is worth exactly 2 weekends a month, and your absence is worth $800 a month, many men internalized that message and retreated. As the 1980s drew to a close, the American family landscape was unrecognizable compared to the 1920s. We had moved from a father as a property owner to a father as an absent breadwinner, and finally to a father as a federally tracked obligor. The state now had a massive computerized infrastructure to ensure he paid, but it had almost no infrastructure to ensure he could actually parent. The system was efficient at collecting dollars, but it was failing at preserving bonds. But a new decade was on the horizon. The 1990s would bring the rise of the at-home dad movement, and the first major challenges to the primary caregiver standard in the Supreme Court. We were moving toward a world where technology wouldn't just be used to track payments, but to facilitate parenting across distances. But before we get there, we have to look at the darker side of the child support revolution. The debtors' prisons of the 1990s and the rise of the Title IV funding system that gave states a direct financial incentive to keep child support amounts high. How did a little-known section of the Social Security Act turn child support into a multi-billion-dollar industry for state governments? And how did this incentive structure create a system that, in many cases, actually worked against the reunification of fathers and children? In the next part, we go deep into the hidden machinery of the child support industry and the fathers who began to hack the system to stay in their children's lives. We are entering the era of the high-stakes Title IV battleground. The hidden machinery of the American family court system is fueled by a piece of legislation that most citizens have never heard of, yet it dictates the lives of millions of fathers every single day. We are talking about Title IV of the Social Security Act. To understand the 1990s experience for a divorced father, you have to understand that child support was no longer just a private arrangement between two parents. It had become a multi-billion-dollar federalized industry. Under Title IV, the federal government provides incentive payments to states based on the amount of child support they collect. This created a profound shift in the historical trends of family law. Suddenly, every state in the union had a direct financial incentive to ensure that child support orders were as high as possible, and that they were collected with relentless efficiency. Imagine if you are a father named James in 1994. James is a skilled carpenter in suburban Detroit. He is recently divorced, and like many men of his era, he is navigating a standard possession order that gives him every other weekend with his 2 daughters. Under the 1988 guidelines we discussed in the previous part, James is ordered to pay a significant percentage of his gross income in child support. But then the early 90s recession hits. James's construction company folds, and he is suddenly unemployed. In a logical world, James would go to court, explain his situation, and his support would be adjusted to reflect his actual income. However, James is about to encounter the Bradley Amendment of 1986, a federal law that prohibits judges from retroactively reducing child support debt. This means that from the moment James loses his job, the clock is ticking, and the debt is permanent. Even if a judge eventually lowers his future payments, the thousands of dollars he accrued while unemployed cannot be touched. It is a debt that follows him to the grave, accruing interest at rates that, in some states, exceed 10% annually. This period saw the rise of what many legal scholars now refer to as the modern debtor's prison. While the United States officially abolished debtors' prisons in the 1830s, the 1990s found a loophole through the use of civil contempt. If James cannot pay his mounting arrears, the Title 4D agency can haul him into court. Because it is a civil matter rather than a criminal one, James is not entitled to a public defender in many jurisdictions. The judge asks James why he hasn't paid. James explains he has no job. The judge, pressured by state performance metrics, may rule that James is willfully underemployed. The court then uses a process called imputing income, where they pretend James is earning what he used to earn, regardless of the actual job market. When James still cannot pay the phantom debt, he is found in contempt and sentenced to county jail. This created a catastrophic cycle. James is in jail so he cannot work. Because he cannot work, his debt grows. Because his debt grows, his license is suspended, making it impossible for him to get to a new job even if he finds one. The potential outcomes for fathers like James during this decade were devastating. Historical trends during the mid-1990s show that the state began to use increasingly creative ways to squeeze payments out of non-custodial parents. This was the era of the Deadbeat Parents Punishment Act of 1992, which made it a federal crime to willfully fail to pay child support for a child in another state. While the intent was to catch wealthy parents fleeing their obligations, the net often caught men who were simply broken by the system. State agencies began publishing the names and photos of the top 10 deadbeats on billboards and in newspapers, a practice of public shaming that further alienated fathers from their communities and their children. Step by step, the 1990s transformed the Title 4D agency from a back-office accounting department into a powerhouse with more surveillance capability than many local police departments. They gained the power to track new hires through the National Directory of New Hires, meaning a father could barely start a new job before his wages were garnished. They gained the power to seize bank accounts, intercept insurance settlements, and even deny the issuance of a passport. For a father in 2026 looking back, it is hard to fathom how quickly these powers were granted with almost no public debate. The narrative was simple and effective. If a father wasn't paying, it was because he was a villain, not because he was struggling. We also have to examine the 1996 Welfare Reform Act under the Clinton administration. This legislation, officially known as the Personal Responsibility and Work Opportunity Reconciliation Act, tied state welfare funding even more tightly to child support enforcement. It required mothers seeking public assistance to cooperate with the state in identifying the father and pursuing support. If a mother wanted to forgive the debt or work out a private arrangement with the father to keep things amicable, the state often forbade it. Once the state provided a single dollar of assistance, they stepped into the mother's shoes and became the primary creditor. The father was now in debt to the government, and the government is a much less forgiving creditor than a former spouse. Case studies from this era reveal a disturbing trend. The state began to view the father-child relationship purely as a financial transaction. If a father was behind on support, the system saw no reason to protect his visitation rights. While the law technically says that visitation and child support are independent issues, in practice, a father who was in arrears often found himself blocked from seeing his children by a custodial parent who felt emboldened by the state's aggressive stance. Many fathers, overwhelmed by the debt and the inability to navigate the complex administrative hearings, simply gave up. They became the disappearing dads of the late 90s, men who felt that their presence only brought stress and legal trouble to their children's lives. However, amidst this crackdown, a counter-movement was growing. In the late 90s, we saw the emergence of a new kind of father's rights advocate. These weren't just men complaining about their ex-wives. They were men who were studying the Title 4D funding structures and the Social Security Act. They began to point out the inherent conflict of interest. If a state receives more federal money for collecting more child support, does that state have any incentive to encourage 50-50 joint physical custody, which usually results in lower child support orders? This question became the rallying cry for a new generation of activists who realized that the battle wasn't just in the family court, but in the halls of state legislatures and the federal government. As we moved toward the new millennium, the tension reached a fever pitch. The technology that allowed the state to track fathers with such precision was also starting to allow fathers to organize in ways that were previously impossible. The early internet gave rise to forums and websites where men could share the secrets of the system, learn how to file their own motions, and support each other through the psychological warfare of the custody battle. The 1990s closed with the father as a hunted man, but the 2000s were about to usher in the era of the pro se father, the man who would walk into court without a lawyer and demand to be treated as a parent, not a paycheck. But there was a new obstacle on the horizon that no one saw coming. While fathers were fighting for their rights in the courtroom, a new psychological concept was being introduced that would threaten to undo all their progress. It was a concept that could turn a child against a loving parent in a matter of weeks, and it would become the new frontline in the custody wars of the 21st century. How did the rise of parental alienation as a legal strategy change the way fathers had to prove their worth? And why did the turn of the millennium see a sudden mysterious spike in fathers being accused of being dangerous precisely when they started asking for more time? In the next part, we enter the era of the high-conflict divorce and the psychological battlefield of the 2000s. We are going to look at how the battle shifted from the wallet to the mind. As the calendar turned to the year 2000, the landscape for the American divorced father underwent a transformation that was less about the ledger and more about the psyche. If the 1980s and 1990s were the decades of the wallet, focused on the Title IV enforcement and the federalization of child support, the first decade of the new millennium became the era of the mind. Looking back from the vantage point of 2026, we can see that this was the moment when the battle moved from how much a father paid to who a father was. This shift introduced a new and often devastating vocabulary into the family court system, including terms like parental alienation, supervised visitation, and the dreaded silver bullet. Imagine if you are a father named Robert in 2004. Robert is an IT manager in Charlotte, North Carolina. He has been married for 12 years, has 2 children, and has always been the one to cook breakfast and handle the bedtime routine. When the marriage ends, Robert expects that his history of hands-on parenting will lead to an equal 50-50 arrangement. However, Robert is about to enter a legal system that, while gender-neutral on paper, has developed a new set of psychological hurdles. In the 2000s, historical trends show that as fathers became more vocal about wanting equal time, the legal pushback shifted toward attacking the father's character or his bond with the children. Robert's attorney warns him that in high-conflict divorces, the most effective way to limit a father's access is no longer to prove he is a poor provider, but to prove he is a psychological threat. This brings us to the rise of parental alienation, or PA. Originally conceptualized by Dr. Richard Gardner in the late 1980s as parental alienation syndrome, the 2000s saw this concept explode in family courts across the United States. Parental alienation occurs when one parent systematically programs a child to distance themselves from, or even hate, the other parent. Case studies from this era reveal a terrifying step-by-step process. First, the alienating parent might begin with subtle disparagement, making negative comments about the father within earshot of the child. Second, they might move to gatekeeping, where they create logistical hurdles that make visitation difficult or stressful for the child. Third, they might share adult details of the divorce with the child, framing the father as the sole cause of the family's suffering. By the time a father like Robert gets to court, his children may be echoing phrases that clearly belong to an adult, yet the court often interprets this as the child's independent voice. The potential outcomes for fathers caught in this psychological crossfire were often tragic. In the early 2000s, many judges were ill-equipped to distinguish between a child who was genuinely afraid of a parent and a child who had been coached to be afraid. This led to a massive increase in the use of supervised visitation centers. Imagine if Robert, who has never had so much as a speeding ticket, is told he can only see his children for 2 hours a week in a windowless room, watched by a social worker with a clipboard. This temporary measure, often implemented while waiting for a custody evaluation, could last for months or even years. The psychological impact on the bond is catastrophic. The father becomes a stranger, and the child's programmed fear is reinforced by the very environment the court created to protect them. During this same period, we saw the emergence of what practitioners called the silver bullet. This was a tactical maneuver where one parent would file a domestic violence restraining order or an allegation of child abuse at the very start of the custody battle. Because the legal standard for a temporary restraining order is often very low, frequently requiring only the testimony of one party, a father could be removed from his home and stripped of his parenting time within 24 hours without ever having a chance to tell his side of the story. While these protections are vital for actual victims of abuse, the historical trends of the 2000s suggest they were frequently used as a strategic first strike to gain exclusive possession of the children and the residence. Once an allegation is made, the father is placed on the defensive. He is no longer fighting for 50-50. He is fighting to prove he isn't a criminal. This tactical escalation contributed to the rise of the pro se father. By the mid-2000s, Many fathers had been financially wiped out by the child support systems of the 90s and the high-conflict litigation of the early 2000s. They could no longer afford the $300 an hour retainers required to fight these psychological battles. These men began to flood law libraries and online forums, learning the rules of evidence and civil procedure themselves. They became a new class of litigant, the father's rights activist who acted as his own attorney. They shared templates for motions, taught each other how to cross-examine a court-appointed psychologist, and began to track the rulings of individual judges to look for patterns of bias. The 2000s also introduced the era of the custody evaluator. When a judge couldn't decide what was in the best interests of the child, amidst conflicting psychological allegations, they would appoint a forensic psychologist to conduct a 730 evaluation or a similar study. This process was incredibly invasive and expensive, often costing between $10,000 and $20,000. For a father like Robert, this meant his entire life was put under a microscope. The evaluator would interview his neighbors, his boss, his parents, and his children. They would observe him playing with his kids for an hour, and then write a 50-page report that could determine his future for the next decade. The problem, as historical trends have shown, is that these evaluators often carried their own internal biases regarding gender roles. A father who was too emotional might be labeled as unstable, while a father who was too stoic might be labeled as detached. Step by step, the 2000s turned the family court into a laboratory of human behavior. The best interest standard became so broad that it allowed for subjective psychological theories to outweigh documented parenting history. However, there was a glimmer of hope. As the decade progressed, the scientific community began to push back. The American Psychological Association and other bodies started to demand more rigorous standards for what constituted alienation versus justifiable estrangement. Fathers began to win cases by proving that the children's rejection was a result of the other parent's interference, leading to the rise of reunification therapy, a controversial but growing field designed to repair the broken father-child bond. As we look toward the end of the 2000s, we see the first major push for legislated 50-50. Fathers had realized that as long as judges had total discretion, the old biases would remain. They began to lobby for state laws that would create a legal presumption of equal shared parenting. They argued that unless a parent was proven unfit, the starting point should always be an equal split. This was the beginning of the end for the standard possession order. But just as the legal tide was starting to turn, a new force was about to disrupt everything: the digital revolution. By 2010, the paper trail wasn't just in the courthouse. It was in the pocket of every parent. Every text message, every Facebook post, and every GPS location was about to become a weapon in the custody wars. How did the rise of social media and the smartphone era turn the 2010s into a period of 24/7 surveillance for divorced dads? And why did the Zoom room of the 2020s change the definition of visitation forever? In the next part, we dive into the 2010s, the decade of the digital evidence explosion. We will look at how a single liked photo on Instagram could cost a father his custody case, and how the fatherhood movement finally went mainstream, moving from the courthouse steps to the halls of the US Congress. The battle was no longer just in the mind, it was in the cloud. We are entering the era of the data-driven dad. The digital revolution of the 2010s did not just change how we communicate, it fundamentally re-engineered the evidence lockers of every family court in the United States. As we transition from the psychological battlefield of the 2000s, we entered an era where the father's entire life became a searchable, indexable, and weaponizable database. This was the birth of the data-driven dad. In this decade, the he-said-she-said arguments that had defined decades of custody litigation were largely replaced by timestamps, metadata, and screenshots. For the American divorced father, the smartphone became both his greatest shield and his most dangerous liability. Imagine if you are a father named Michael in 2014, living in a tech-heavy city like Seattle. Michael is a software engineer who, following his divorce, is seeking an equal 50-50 parenting schedule. In previous decades, Michael might have struggled to prove his daily involvement in his children's lives. But in 2014, Michael has a digital trail. He has text messages showing he coordinated every doctor's appointment. He has GPS data from his fitness app proving he was at the soccer field every Tuesday at 4 p.m. He has Amazon receipts for school supplies and grocery deliveries. This is the era where fathers began to use data to dismantle the primary caregiver myth. By presenting a chronological, verified log of their parenting activities, Fathers like Michael could move past the subjective biases of a court-appointed evaluator and present an objective reality of their role in the household. However, this digital transparency was a double-edged sword. Historical trends in the 2010s show a massive spike in the use of electronic discovery, or e-discovery, in family law. Potential outcomes for a father who was not digitally disciplined could be catastrophic. Imagine if Michael, during a particularly stressful weekend, sends a frustrated text message to his ex-wife at 2 a.m. In the 1980s, that comment would have vanished into the air. In 2014, that text is screenshotted, backed up to the cloud, and presented to a judge as Exhibit A to prove Michael has anger management issues or is emotionally unstable. We saw the rise of the digital shadow, where a father's social media activity, even posts made years prior, were scrutinized for signs of a lifestyle that a judge might deem inconsistent with the best interests of the child. A single photo of a father holding a beer at a backyard barbecue, if poorly timed or framed, could be used to argue for a substance abuse evaluation. This led to a step-by-step professionalization of the divorced father. Fathers began to realize that every digital interaction was a potential legal document. This realization birthed the widespread adoption of co-parenting communication applications like Our Family Wizard and Talking Parents. By the mid-2010s, judges across the U.S. began mandating the use of these platforms. These apps changed the game by creating an unmodifiable record of communication. They included features like read receipts, which prevented one parent from claiming they never saw a message about a school play, and tone meters, which warned users if their message sounded aggressive before they hit send. For fathers, these apps provided a level of protection against false accusations of harassment, as every interaction was monitored and archived for the court's review. As the data became more central to the case, the legal philosophy began to shift as well. We began to see the move away from the word custody toward the term parenting time or time sharing. This was more than just a linguistic change. It reflected a growing recognition that children do not belong to a parent, but rather have a right to access both parents. The 2010s were the decade of the rebuttable presumption. Advocacy groups, now organized through social media and digital platforms, began a massive push for state laws that would require judges to start with the assumption that equal parenting is best. The most pivotal moment of this decade occurred in 2018 in Kentucky. Kentucky became the first state to pass a law, House Bill 528, which created a rebuttable presumption that joint custody and equal shared parenting time are in the best interests of the child in all divorce cases. This was a historical landmark. For the first time, the burden of proof shifted. It was no longer the father's job to prove why he should have 50% of the time. It became the opposing party's job to prove why he should not. Case studies following the implementation of this law showed a significant decrease in high-conflict litigation, as the default outcome was already established by law, leaving less room for tactical maneuvering. Furthermore, we must examine the impact of the gig economy and remote work on the 2010s father. Before the widespread adoption of high-speed home internet and cloud computing, many fathers were trapped by the 9-to-5 office requirement, which courts used as a justification to award primary custody to the mother. As remote work became more common in the mid-2010s, fathers could finally argue that they were just as available for school pickups and sick days as any other parent. The economic argument for the father as a secondary figure was crumbling. Fathers were no longer just providers from a distance. They were present, connected, and capable of managing both a career and a household simultaneously. This decade also saw the rise of the fatherhood influencer. Platforms like YouTube and Facebook allowed divorced fathers to share their stories on a global scale. This created a sense of community that had been missing in the 1990s. Men were no longer suffering in isolation. They were watching videos on how to navigate a Title IV hearing, how to respond to parental alienation, and how to maintain a bond with their children through video calls and digital gaming. This mainstreaming of the fatherhood movement put pressure on the legal system. When millions of men are sharing their experiences of systemic bias online, the black box of the family court begins to transparentize. By 2019, the American divorced father was more informed, more connected, and more legally empowered than ever before. He was a man who understood the value of his digital footprint and the power of legislated equality. He was moving out of the visitor role and into the co-lead role. But just as the momentum for equal parenting seemed unstoppable, a global event was about to occur that would stress test every single parenting plan in the country. The upcoming decade would start with a crisis that would lock fathers out of their children's lives in some cases, while in others, It would force a level of co-parenting cooperation that had never been seen before. How did the lockdowns of the early 2020s create a new kind of visitation crisis, where a parent's health status became a legal weapon? And why did the shift to virtual courtrooms in 2021 actually help many fathers gain more time by removing the logistical barriers of the traditional courthouse? In the next part, we move into the 2020s, the era of the pandemic parent and the rise of the virtual visitation revolution. We are going to look at how the definition of home changed overnight and what that meant for the dads who were fighting to stay in the picture during a time of global isolation. The battle was about to move from the physical world into a new hybrid reality. The transition into the 2020s represented a moment of unprecedented disruption for the American family court system, a disruption that eventually forced a total reimagining of what it means to be a present father. We entered a hybrid reality where the physical presence of a parent was suddenly weighed against the perceived safety of a public health crisis. To understand the plight of the divorced father in 2026, we must look back at the chaos of 2020 and 2021, when the standard rules of engagement were suspended, and fathers found themselves navigating a legal landscape where the goalposts moved almost weekly. Imagine if you are a father named Kevin in April 2020. Kevin lives in a suburb of Chicago and has a court-ordered schedule that allows him to see his 7-year-old daughter every Wednesday and every other weekend. When the first stay-at-home orders are issued, Kevin's ex-wife informs him that she will not be exchanging the child. She cites a fear of virus exposure and the general uncertainty of travel. In the early months of the pandemic, historical trends show that thousands of fathers like Kevin were effectively locked out of their children's lives with no immediate legal recourse. The courthouses were shuttered for non-emergency matters, and for many judges, a routine custody exchange did not qualify as an emergency. This period created a massive, unintended experiment in visitation. Case studies from 2020 reveal a disturbing trend where the health crisis was occasionally used as a tactical weapon in ongoing custody disputes. Some custodial parents argued that the father's job, perhaps he was a first responder, a delivery driver, or worked in a grocery store, made him a high-risk individual whose presence threatened the safety of the child's primary household. Fathers were forced to choose between their livelihoods and their parenting time. Potential outcomes for these men were often bleak. If they went to work, they lost their children. If they stayed home to prove their safety, they lost the income necessary to pay the child support that the Title IV agencies were still aggressively tracking. Step by step, the legal system had to catch up to this new reality. By the summer of 2020, various state Supreme Courts, beginning with Texas and followed quickly by Florida and Ohio, issued emergency declarations. These orders stated clearly that the pandemic was not a valid reason to violate a custody order. They ruled that the existing schedule was the law of the land and that parents were expected to follow it regardless of stay-at-home mandates. This was a critical victory for fathers' rights, as it established that the parent-child bond was an essential service. However, the damage for many had already been done. The months of missed time created a new legal phenomenon: the battle for make-up time. Fathers in 2021 and 2022 spent thousands of dollars in legal fees just to reclaim the weeks and months they had lost during the initial lockdowns. But the pandemic also brought about a technological leap that would eventually benefit fathers in ways no one had predicted. This was the era of the virtual visitation revolution. Before 2020, a video call was seen as a poor substitute for a visit. By 2021, it became a sophisticated, multi-layered parenting tool. Fathers began to use platforms like Zoom and FaceTime not just for a 5-minute, "How was your day?" call, but for immersive co-parenting. We saw the rise of fathers who would stay on a video link for 2 hours to help their children with remote learning. They played online video games like Roblox or Minecraft together, using digital avatars to maintain a sense of shared space. This shifted the definition of visitation from a passive event to an active, engaged partnership. Furthermore, the shift to virtual courtrooms changed the power dynamics of the legal process. Imagine the impact on a father who previously had to take a full day off work, lose 8 hours of pay, and pay for parking just to sit in a hallway for a 15-minute hearing. In the 2020s, that same father could log into a Zoom hearing from his lunch break. Historical data suggests that virtual hearings significantly increased the participation rates of non-custodial fathers, especially those in lower-income brackets. It leveled the playing field by removing the logistical and financial barriers to being heard by a judge. The court, once a distant and intimidating fortress, was now a window on a laptop screen. The most profound long-term shift, however, came from the labor market. As remote work and flexible schedules became the standard for millions of American workers, the traditional argument used against fathers, that they were too busy with work to handle 50-50 custody, evaporated. By 2023 and 2024, fathers were walking into court and proving that they could handle school drop-offs, midday doctor appointments, and homework because their office was now in their spare bedroom. This led to a massive surge in the number of fathers successfully obtaining equal parenting time. The economic structures that had supported the mother as primary caregiver model for over a century were finally dismantled by the transition to a digital economy. In the 2020s, we also saw the rise of the parenting plan pandemic clause. Legal practitioners began drafting specific language into new decrees that outlined exactly what would happen in the event of future national emergencies or school closures. This was a direct response to the Kevin scenario of 2020. These clauses ensured that no parent could unilaterally suspend visitation based on a subjective assessment of public safety. It codified the father's right to be a parent, even when the world is in crisis. However, as we look at the state of fatherhood in 2026, a new set of challenges has emerged from this digital shift. The data-driven nature of the 2010s has evolved into something even more intense: the surveillance state of co-parenting. With the widespread use of shared digital calendars, school portals, and health tracking apps, the divorced father is under constant scrutiny. In 2026, if a father forgets to log a child's temperature in a shared health app, or if he misses a digital notification from a teacher, it is recorded as a failure in real time. The hybrid reality means that the father is present 24/7, but he is also judged 24/7. As we move through the middle of this decade, we are seeing the first generation of children who have grown up with two-home fluidity as their primary social reality. These children do not see their fathers as visitors. They see them as co-executives in the corporation of their lives. But this level of involvement requires a level of communication and cooperation that many parents still struggle to achieve. The high-conflict divorce hasn't disappeared. It has simply moved into the cloud. The 2020s proved that the American father is resilient, but it also exposed how fragile his legal standing can be when the traditional structures of society are shaken. We have moved from the visitor of the 1950s to the obligor of the 1980s, and now to the hybrid co-parent of the 2020s. But there is one final wall that has yet to fall. Despite the technological advances and the legislative wins in states like Kentucky, there remains a deep-seated cultural resistance to the idea that a father is truly equal to a mother in the eyes of the law. How did the rising cost of living and the inflation crisis of the mid-2020s create a new financial trap for divorced dads, where 50-50 custody became an economic impossibility for some, despite being a legal right? And why are we now seeing a movement of fathers who are choosing to bypass the court system entirely in favor of private family contracts? In the next part, we dive into the economic warfare of the mid-2020s and the rise of the DIY divorce. We are going to look at how the 2026 father is fighting the ultimate battle. The battle for his own financial survival in a system that still wants his paycheck more than his presence. The shift is moving from the law to the economy. Are you ready for the era of the decentralized dad? As we sit here in the middle of 2026, the American landscape for a divorced father has evolved into a high-stakes game of economic survival. We have entered the era of the decentralized dad, a term that describes a generation of men who are attempting to parent effectively while navigating the most hostile financial environment in a century. The legal victories of the 2010s, which established a stronger foothold for equal parenting time, are now slamming headfirst into the brutal reality of the mid-2020s economy. In 2026, the question is no longer just whether a father has the right to see his children, but whether he can afford the price of entry required by a system that was built for a different world. Imagine if you are a father named Alex in 2026, living in a high-cost urban center like Austin or Charlotte. Alex successfully fought for a 50-50 custody arrangement 3 years ago. On paper, he is an equal parent, but in the current year, Alex is facing the real estate trap. To maintain his 50-50 status, the court requires Alex to provide a home with adequate space for his children, usually meaning a separate bedroom for each child if they are of a certain age or gender. However, between 2022 and 2026, the cost of a 3-bedroom apartment in a safe school district has increased by nearly 40%. Alex now finds himself in a position where his rent consumes 60% of his take-home pay. He is living on the edge of insolvency just to maintain the physical infrastructure required to be a dad. This is a historical trend we are seeing across the United States. The economic disqualification of fathers. If Alex loses his apartment and moves into a studio, his ex-spouse can immediately file for a modification of custody based on a change in circumstances, arguing that his home is no longer suitable. This economic pressure is compounded by the failure of the child support formulas established in the late 1980s. These formulas, which we analyzed in previous parts, were designed in an era of 3% inflation and stable housing markets. In 2026, these calculations are arguably obsolete. The income shares model assumes that the cost of raising a child remains a fixed percentage of income, but it fails to account for the localized hyperinflation of essential goods like insurance, tuition, and groceries. When Alex's child support was calculated in 2023, eggs were $3 a dozen and health insurance premiums were manageable. In 2026, the cost of living has outpaced his wage growth. Yet, the Title IV agencies we discussed earlier continue to use automated, algorithmic enforcement. If Alex's company skips a cost of living adjustment, the state doesn't care. The garnishment remains the same, leaving Alex with less and less for his own survival. This creates a new kind of functional poverty for divorced dads. They have a good job and a mid-six-figure salary on paper, but after taxes, support, and the cost of a second household, they are effectively living below the poverty line. Step by step, this economic squeeze has led to the rise of the DIY divorce and the rejection of the adversarial legal model. In 2026, historical trends show that more fathers are choosing to bypass the traditional courtroom entirely. They are turning to private family contracts. These are legally binding agreements drafted outside of the court-supervised system, often through mediation or private arbitration. Why is this happening now? Because the cost of a contested custody trial in 2026 has reached an average of $50,000 per side. For a man like Alex, spending $50,000 to win a 50-50 schedule, he already has as a form of financial suicide. Fathers are now using decentralized legal platforms, powered by blockchain or smart contract technology, to create parenting plans that automatically adjust based on inflation or changes in income without the need for a $300 an hour attorney to file a motion. We are also seeing the emergence of co-parenting cooperatives. Imagine if Alex, unable to afford a 3-bedroom house on his own, rents a large home with another divorced father in the same situation. They share the common areas, but each has a wing for their children during their respective weeks of custody. While this solves the housing crisis, it creates a new legal headache. Historical trends in 2026 show that some family court judges view these non-traditional living arrangements with suspicion, sometimes labeling them as unstable environments. This is the final frontier of the cultural battle. The court's insistence on a nuclear family aesthetic, even when the nuclear family budget no longer exists. Furthermore, the 2026 father is dealing with the impact of the gig economy on support obligations. Many men now hold multiple side hustles to keep up with inflation. In a traditional 1990s court setting, this extra income would be immediately factored into a higher child support order. However, the decentralized dad is becoming more sophisticated in how he manages his assets. We are seeing a shift where fathers are moving resources into digital assets or private trusts to protect their ability to provide for their children directly, rather than through a state-mediated check. This isn't about avoiding responsibility, it's about reclaiming agency. Fathers are arguing that they would rather spend $500 directly on their child's new computer than send $500 into the state's Title IV machinery, where a portion of it is siphoned off for administrative fees and the father has no say in how it is spent. Case studies from this year suggest that this financial rebellion is actually leading to better outcomes for children. When parents are not locked in a state-mandated financial war, their ability to co-parent improves. The 2026 movement is toward transparency over enforcement. Fathers are demanding direct-to-child support models, where expenses are paid directly to providers, like schools or doctors, rather than being handed over as a lump sum to the custodial parent. This reduces the friction of hidden spending and ensures the father knows exactly where his hard-earned money is going. However, there is a dark side to this decentralized era. For fathers who are not tech-savvy or who work in traditional industries where every penny is tracked by W-2 reporting, the 2026 economy is a vice. These men are the most vulnerable to the debtor's prison cycle we explored in the 90s. As the cost of living rises, the gap between what the court thinks a father should pay and what he can actually afford is widening into a chasm. We are seeing a spike in voluntary homelessness among divorced dads. Men who live in their trucks or offices during their off weeks, so they can afford the luxury of a home for their children during their custody weeks. As we look toward the final parts of this masterclass, we have to ask, if the law has given fathers the time, but the economy is taking away their ability to use it, is the victory of the 2010s a hollow one? We are witnessing a clash between a 20th century legal system and a 21st century economic collapse. The decentralized dad is the response to that clash, but it is a risky and exhausting way to live. But there is one major development we haven't touched on yet. While the fathers are decentralizing their finances, the state is centralizing its surveillance. In 2025, a landmark Supreme Court case changed the way the federal government can use family data to influence state funding. This case has set the stage for a final showdown. If the state loses its financial incentive to keep fathers and mothers in conflict, what happens to the multi-billion-dollar child support industry? And how does the social credit score of 2026 parenting impact a father's ability to stay in the home? How did a 2025 legal ruling regarding parental algorithmic bias finally give fathers the tool they needed to sue the system itself? And why are we seeing a massive exodus of divorced dads to pro-father states, creating a new map of the American family? In the next part, we dive into the great migration of the American dad and the legal war against the algorithms. The battle is no longer about one man in one courtroom. It is about the entire architecture of the American family law industry. Are you ready for the revolt against the machine? The year 2026 has arrived with a digital iron fist, marking the moment when the American family court system transitioned from human-centric judgment to algorithmic oversight. To understand the plight of the modern divorced father, we must look at the legal war currently being waged against the machine. We are no longer just discussing the biases of a single judge in a wood-paneled courtroom. We are discussing the automated, high-velocity processing of family rights through software that was never designed to account for the nuances of human love. This is the era of the algorithmic father, and the revolt that began in early 2025 is now reaching a fever pitch in 2026. Imagine if you are a father named Jason living in a high-tech hub like San Francisco or Austin. Jason is a civil engineer who has always been a hands-on parent, but when his marriage dissolved in late 2024, he entered a system that had replaced the traditional custody evaluator with a proprietary risk assessment tool called Parent Guard AI. Step by step, Jason watched as his entire life was fed into a black box. The algorithm scanned his social media, his bank statements, his work-from-home logs, and even the GPS data from his vehicle. Based on historical trends that the AI was trained on, data predominantly from the 1990s and 2000s, the software assigned Jason a parental engagement score. Because the AI associated stability with the traditional primary caregiver model of the past, Jason was flagged as a secondary figure. The software didn't care that Jason's work-from-home hours were spent building Legos with his son. It only saw that he worked 45 hours a week and concluded he was a less viable primary candidate. This led to the landmark 2025 Supreme Court case, Harrison versus Digital Family Services, which has become the focal point of the fatherhood movement in 2026. This case was the first to successfully argue that using proprietary, non-transparent algorithms to determine the fundamental rights of parents is unconstitutional. The potential outcomes of this ruling are currently reshaping every family court in the United States. For the first time, fathers like Jason have the right to audit the algorithm. This means their attorneys can subpoena the source code of the software used to calculate their support and custody. What they are finding is a phenomenon known as historical data poisoning. The AI models were trained on decades of rulings where the tender years doctrine and the primary caregiver standard were the default, effectively teaching the computer that fathers are less essential than mothers. In 2026, the battle is to purge this legacy code from the legal system. As this technological war unfolds, we are witnessing the great migration of the American dad. Historical trends in 2026 show a massive shift in population, as divorced fathers literally flee states with discretionary custody laws. Imagine if Jason, realizing that the courts in his home state are still heavily influenced by biased algorithms, decides to pack his life into a moving truck. He is moving to Kentucky, West Virginia, or Florida, states that have passed mandatory 50-50 presumption laws. This is jurisdiction shopping on a massive scale. Fathers are moving their businesses, their taxes, and their lives to states where the law explicitly states that the starting point for any custody case is an equal split of time. This migration is creating a new map of the American family, where your rights as a father are determined by which side of a state line you sleep on. We must also examine the 2026 revolt against the Title IV funding machine. As we discussed in earlier parts of this masterclass, states receive federal incentives based on the amount of child support they collect. In 2026, a massive class action lawsuit is moving through the federal courts, alleging that this funding structure creates an inherent conflict of interest. The argument is simple yet devastating. If the state makes more money when a father has less time, because less time usually leads to higher support orders, then the state has a financial incentive to deny fathers equal custody. Case studies from this year show that in states with high Title IV reliance, the rate of 50-50 custody remains significantly lower than in states that have decoupled their budgets from support collection. Fathers are now demanding an end to what they call state-sponsored fatherlessness, where the government profits from the marginalization of the non-custodial parent. Step by step, the 2026 father is becoming a legal insurgent. These men are not just appearing in court, they are appearing with data scientists and constitutional scholars. They are filing interlocutory appeals the moment a judge uses an automated guideline that hasn't been audited for gender bias. They are using the very technology that was meant to track them, their smartphones and wearable devices, to create verifiable parenting logs. In 2026, a father can walk into court with a blockchain-verified record of every diaper changed, every meal cooked, and every hour spent on homework. This high-fidelity parenting data is making it nearly impossible for judges or algorithms to maintain the myth of the father as a secondary visitor. However, the machine is fighting back. We are seeing the rise of predictive child support. In some jurisdictions, the state is now using AI to predict a father's future earnings potential and setting support orders based on what the computer thinks he could earn, rather than what he actually earns. This is the ultimate extension of the imputed income practice we saw in the 90s. If the algorithm decides Jason has the potential to be a vice president, it will order him to pay support as if he already has that salary. This creates a debt trap that is almost impossible to escape, forcing men into high-stress careers they don't want just to avoid incarceration for civil contempt. The 2026 landscape is a paradox. On one hand, fathers have never had more legal tools to fight for equality. On the other hand, the system has never been more efficient at automating their exclusion. We are seeing the emergence of the Pro Se 2.0 father men who use AI themselves to draft their motions, research case law, and predict how a specific judge will rule based on historical data. They are fighting fire with fire. The courtroom has become a battle of the bots, where the father's AI lawyer fights the state's AI enforcement bot. But amidst the data and the lawsuits, there is a growing psychological movement called the reconnection. In 2026, we are seeing a record number of cold cases being reopened. Fathers who were pushed out of their children's lives in the 2010s are using new reunification statutes to demand a seat at the table. They are arguing that the trauma of the visitor model was a violation of their children's civil rights. This is the first generation to frame fatherhood not just as a parental right, but as a civil rights issue. As we look toward the final part of this decade-long journey, we have to face the ultimate question. If the 2026 father wins the war against the machine, if he achieves legislative 50-50th, audits the algorithms and dismantles the Title IV incentives, what does the American family actually look like? Are we moving toward a world of true equality? Or have 100 years of legal warfare created a permanent state of tension between the sexes? We are standing on the precipice of a new social contract. How did the final settlement of 2027 change the way we define family in the United States forever? And why is the role of the divorced dad about to disappear entirely, replaced by something called fluid parenting? In our final part, we look into the future. We are going to explore the vision of the next century, and how the struggles of the last 100 years have paved the way for a world where visitation is a word found only in history books. The revolution is almost complete. Are you ready for the final piece of the puzzle? The year 2026 has arrived with a digital iron fist, marking the moment when the American family court system transitioned from human-centric judgment to algorithmic oversight. To understand the plight of the modern divorced father, we must look at the legal war currently being waged against the machine. We are no longer just discussing the biases of a single judge in a wood-paneled courtroom. We are discussing the automated, high-velocity processing of family rights through software that was never designed to account for the nuances of human love. This is the era of the algorithmic father, and the revolt that began in early 2025 is now reaching a fever pitch in 2026. Imagine if you are a father named Jason living in a high-tech hub like San Francisco or Austin. Jason is a civil engineer who has always been a hands-on parent, but when his marriage dissolved in late 2024, He entered a system that had replaced the traditional custody evaluator with a proprietary risk assessment tool called Parent Guard AI. Step by step, Jason watched as his entire life was fed into a black box. The algorithm scanned his social media, his bank statements, his work-from-home logs, and even the GPS data from his vehicle. Based on historical trends that the AI was trained on, data predominantly from the 1990s and 2000s, the software assigned Jason a parental engagement score. Because the AI associated stability with the traditional primary caregiver model of the past, Jason was flagged as a secondary figure. The software didn't care that Jason's work-from-home hours were spent building Legos with his son. It only saw that he worked 45 hours a week and concluded he was a less viable primary candidate. This led to the landmark 2025 Supreme Court case, Harrison versus Digital Family Services, which has become the focal point of the fatherhood movement in 2026. This case was the first to successfully argue that using proprietary, non-transparent algorithms to determine the fundamental rights of parents is unconstitutional. The potential outcomes of this ruling are currently reshaping every family court in the United States. For the first time, fathers like Jason have the right to audit the algorithm. This means their attorneys can subpoena the source code of the software used to calculate their support and custody. What they are finding is a phenomenon known as historical data poisoning. The AI models were trained on decades of rulings where the tender years doctrine and the primary caregiver standard were the default, effectively teaching the computer that fathers are less essential than mothers. In 2026, the battle is to purge this legacy code from the legal system. As this technological war unfolds, we are witnessing the great migration of the American dad. Historical trends in 2026 show a massive shift in population, as divorced fathers literally flee states with discretionary custody laws. Imagine if Jason, realizing that the courts in his home state are still heavily influenced by biased algorithms, decides to pack his life into a moving truck. He is moving to Kentucky, West Virginia, or Florida, states that have passed mandatory 50-50 presumption laws. This is jurisdiction shopping on a massive scale. Fathers are moving their businesses, their taxes, and their lives to states where the law explicitly states that the starting point for any custody case is an equal split of time. This migration is creating a new map of the American family, where your rights as a father are determined by which side of a state line you sleep on. We must also examine the 2026 revolt against the Title IV funding machine. As we discussed in earlier parts of this masterclass, states receive federal incentives based on the amount of child support they collect. In 2026, a massive class action lawsuit is moving through the federal courts, alleging that this funding structure creates an inherent conflict of interest. The argument is simple yet devastating. If the state makes more money when a father has less time, because less time usually leads to higher support orders, then the state has a financial incentive to deny fathers equal custody. Case studies from this year show that in states with high Title IV reliance, the rate of 50-50 custody remains significantly lower than in states that have decoupled their budgets from support collection. Fathers are now demanding an end to what they call state-sponsored fatherlessness, where the government profits from the marginalization of the non-custodial parent. Step by step, the 2026 father is becoming a legal insurgent. These men are not just appearing in court, they are appearing with data scientists and constitutional scholars. They are filing interlocutory appeals the moment a judge uses an automated guideline that hasn't been audited for gender bias. They are using the very technology that was meant to track them, their smartphones and wearable devices, to create verifiable parenting logs. In 2026, a father can walk into court with a blockchain-verified record of every diaper changed, every meal cooked, and every hour spent on homework. This high-fidelity parenting data is making it nearly impossible for judges or algorithms to maintain the myth of the father as a secondary visitor. However, the machine is fighting back. We are seeing the rise of predictive child support. In some jurisdictions, the state is now using AI to predict a father's future earnings potential and setting support orders based on what the computer thinks he could earn, rather than what he actually earns. This is the ultimate extension of the imputed income practice we saw in the 90s. If the algorithm decides Jason has the potential to be a vice president, it will order him to pay support as if he already has that salary. This creates a debt trap that is almost impossible to escape, forcing men into high-stress careers they don't want just to avoid incarceration for civil contempt. The 2026 landscape is a paradox. On one hand, fathers have never had more legal tools to fight for equality. On the other hand, the system has never been more efficient at automating their exclusion. We are seeing the emergence of the Pro Se 2.0 father men who use AI themselves to draft their motions, research case law, and predict how a specific judge will rule based on historical data. They are fighting fire with fire. The courtroom has become a battle of the bots, where the father's AI lawyer fights the state's AI enforcement bot. But amidst the data and the lawsuits, there is a growing psychological movement called the reconnection. In 2026, we are seeing a record number of cold cases being reopened. Fathers who were pushed out of their children's lives in the 2010s are using new reunification statutes to demand a seat at the table. They are arguing that the trauma of the visitor model was a violation of their children's civil rights. This is the first generation to frame fatherhood not just as a parental right, but as a civil rights issue. As we look toward the final part of this decade-long journey, we have to face the ultimate question. If the 2026 father wins the war against the machine, if he achieves legislative 50-50th, audits the algorithms and dismantles the Title 4D incentives, what does the American family actually look like? Are we moving toward a world of true equality? Or have 100 years of legal warfare created a permanent state of tension between the sexes? We are standing on the precipice of a new social contract. How did the final settlement of 2027 change the way we define family in the United States forever? And why is the role of the divorced dad about to disappear entirely, replaced by something called fluid parenting? In our final part, we look into the future. We are going to explore the vision of the next century, and how the struggles of the last 100 years have paved the way for a world where visitation is a word found only in history books. The revolution is almost complete. Are you ready for the final piece of the puzzle?